Okay, we will reconvene this meeting of the Veterinary Medical Board, and we will move on to 6B, the third item, talking about the veterinary client-patient relationship and telehealth. Anne Marie.
Yeah, okay. So telehealth, really this language came out of the last Veterinary Medical Board meeting, and the language as we voted on it in July referred to telemedicine, which was the term that was used to discuss a mode of delivery that is something other than in person. The actual terminology used in the medical field is telehealth. Tara made some suggested changes. If you look at 2032.1, and again, just for the public record, we decided to put the telehealth language within the veterinary client-patient relationship. So if you look at subdivision E and F, and there are a few changes made that are just more non-substantive, kind of conforming changes in subdivision D. This really represents the board's motion at the last meeting with a change to the term telehealth as opposed to telemedicine, but there really wasn't anything substantive in terms of the context of this language changed. So this is just for the board to give us the authority to move forward with a regulatory proposal as amended.
Okay, so after reviewing the Business and Professions Code section on telehealth, which applies to all practitioners licensed under Division 2, which includes veterinarians, we're thinking that perhaps we should go back to the use of telemedicine in subdivision F, and then actually defining it, giving it a very small definition that provides a direction that this is not telehealth, which is broader. So what I'm proposing is on subdivision F of CCR section 2032.1, changing telehealth to read telemedicine shall be conducted within an existing VCPR, continuing that same, the rest of the sentence, but adding a new sentence which would read, for purposes of this section, comma, quote, telemedicine, end quote, shall mean the mode of delivering animal health care services via communication technologies to facilitate the diagnosis, comma, consultation, comma, treatment, comma, and care management of the patient. So the difference is, I'm sorry.
Can you repeat that?
Yeah.
Just for the purposes of this section.
Mm-hmm. Quote, telemedicine, end quote, shall mean the mode of delivering healthcare services via communication technologies to facilitate the diagnosis, comma, consultation, comma, treatment, comma, and care management of the patient, period. So the difference here is that telehealth under Business and Professions Code includes diagnosis, consultation, treatment, education, care management, and self-management of a patient's health care. So it's broader than what the committee was contemplating with the provision for telemedicine. So effectively, it's just a smaller category.
Did you get that from someplace else? And should it be the act of instead of the mode of delivering?
So I'm using the definition of telehealth, but modifying it so that it's the smaller subset of authorized activities.
Right.
And,
And in that definition,
yeah, in the definition for telehealth, it says, means the mode of delivering healthcare services.
but isn't it an act that we are defining?
No, I think we're defining that it's via phone or computer rather than in person. So it's the mode of providing the healthcare services.
I mean, when you do that, like practicing veterinary medicine, then I think it's an act if you're practicing veterinary medicine.
Well, what the mode is referring back to is telemedicine being a type of delivery system. So it's not defining the service, it's defining the mode of delivery. I think that's how it's being defined, right?
You regulate the
Act itself, so telemedicine is the mode of delivery. That's how it's being delivered. But then the services is what you're referring to, the act. So these animal healthcare services are the act that we're
All right.
under that mode.
Okay, any other discussion? I know it's gonna take a while to digest this. You need it read again?
Okay.
Could you read it again, please? Sure.
For purposes of this section, comma, quote, telemedicine, quote, shall mean the mode of delivering animal healthcare services via communication technologies to facilitate the diagnosis, comma, consultation, comma, treatment, comma, and care management of the patient.
Yes.
Contemplating.
I'm contemplating this myself. Yes, Dr. Sullivan.
I move to approve.
I second it.
Second?
I second it.
Okay, any other discussion? Any comments from the public?
Grant Miller, Regulatory Director, CBMA. In relation to Section F, and Ms. Walsh and I had discussed this previously, but on the record, we want to make sure that the word veterinary is changed to veterinarian in client-patient relationship. Thank you.
We need to do that in a couple of the different regulatory documents for
And
consistency.
Can we just do that from now till the end of time?
Yeah.
Standing
Why not?
request from the CBMA. Thank you.
Any other comments? We have a motion and a second. Any other comments from the board? Should we call for the vote?
Decided just grant, okay. Yeah. Okay, calling for the vote. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
Dr. Nunez?
Yes.
Okay. And the motion is,
Motion
sorry,
passes.
Tara, let me read the motion so we
Oh,
we
yes.
don't get ourselves in
There we go.
trouble. This motion is to approve as amended. The proposed regulatory changes is direct the executive officer to take all necessary steps to initiate the rulemaking process, authorize the executive officer to make any technical or substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, the proposed regulatory changes, adopt the proposed regulatory changes as modified. No, no.
We're okay?
Yeah.
Okay. Moving on to 6B, the topic on animal physical rehabilitation.
Okay, again, this reflects the board's recommendation from the April meeting, the language that's before you, it is pertinent to RVTs and those classified as veterinary assistants. I do want to point out that there is an additional document in the packet that was distributed at the last meeting. The document was a little confusing in that prior to the changes that I've made for this meeting, item 8 appeared to be the recommendation out of the task force that was then adopted by the Veterinary Medical Board, when in fact item 8 came out of the task force, the Animal Physical Rehabilitation Task Force, and the board amended the motion, and the motion of the board is actually item 9. So this document serves to clarify what actually occurred in the process of the task force and then the board's motions. Again, this is here for clarification. In terms of the language itself, Tara did revise some of the language, and her footnotes are included in the document to conform with the regulatory usage of performing tasks, that referring to RVTs. And then there was some rewording of the language under subdivision E to make the language just more clear for the purposes of regulation. So I'm going to open it up for discussion.
Discussion from the board? Comments?
And here we actually have a veterinarian client-patient relationship.
Do we need a motion?
No comments? Yes, we need a motion then. Yes, Dr.
I
Sullivan?
move that we submit this regulation for processing.
I'll second. Jennifer seconded. Any comments from the public?
Diane Isbell, equine veterinarian. I'm a regulatory veterinarian at the racetrack, and I have a private ambulatory practice off the track. I would suggest that under the veterinary assistant, that in the large animal range setting, the veterinarian be allowed to determine the degree of supervision. And I say this for 2 reasons. One, horses are dangerous. I can't just bring anybody in off the street to work for me. Horses kick, a little known fact, with 900 pounds per square inch pressure. Just the circumference of the shoe is at 1.5 tons for 1 foot, and that is a deadly force. We equine vets pay 10 times that of a small animal vet for our liability insurance, not because of the value of the animal, but because the degree of human injury that's associated with it. And over the years, I've read in the liability newsletter about multiple compound fractures, internal injuries such as ruptured spleens, and the occasional death that occurs due to chest or head trauma from horses. So I have to find, be they an RVT or a veterinary assistant, I have to find somebody that already has a good set of horse handling skills. They're aware of the horse, they're aware of the environment around them, the things that can spook them. They're aware of the audience that shows up when the vet comes or anybody comes to work on the horse. And they have the skills to control the situation. The other problem is finding an RVT with that level of skills for the equine world. I live in the Bay Area. We're a fairly populous area. There's lots of horses. You'd think I could find someone. I've looked for 4 years, and I could only find 2 that are actually already hired, and they don't want to commute through our traffic to where I would be working. It is not so difficult to find a veterinary assistant, somebody who has worked with a group of horses, managed a group of horses, and can certainly, they will already come with a subset of rehabilitation skills because horses are always injuring themselves. So it is possible to find a veterinary assistant, not easy, but possible. I've robbed a couple from the racetrack to work for me part-time. So due to the dangerous nature of horses, the need to have somebody quite skilled in working with them, and the unfortunate dearth of RVTs who have that level of skill for horses, I suggest that the veterinary assistant be changed only in the large animal range setting to the level of supervision to be determined by the veterinarian.
So I believe as it reads, is,
see
for
it.
large animal practice, the appropriate degree of supervision shall be determined by the veterinarian who established the veterinarian client-patient relationship in a range setting.
No, not in the actual
No.
language.
But that's not in this language.
Right, because you didn't vote to approve that. You voted to approve at the last meeting for veterinary assistants. So in the language itself, veterinary assistants may perform animal physical rehab under the direct supervision of a veterinarian. That motion was made in April, and it is covered, actually, it was made in July, and it is covered in the document, the very last motion. So the motion before that refers to physical therapists, and the only way for that motion to be adopted by some form of regulatory construct is for there first to be a statute that recognizes physical therapists as someone who can practice veterinary medicine under the Practice Act. So we're not dealing with statute today. Today we're dealing with regulation. And so the regulation proposed in July is documented in this separate document, but it is also in the language before you today.
Comments?
I guess I feel like we made a mistake. I thought we were going to add for a large animal practice, the appropriate degree of supervision shall be determined by the veterinarian for veterinary assistance in a range setting. I guess I missed that.
Dr. Sullivan?
Well, the veterinarian still has, I mean, the reason we're having this wording here is that the veterinarian still can make the decision whether that RVT is under direct or indirect supervision.
They're talking about the veterinary.
That text.
I know, that's what I'm getting to. We don't have any authority over anybody else other than somebody that's licensed. So the veterinary assistant, whether they're off the street or have a PhD, they're still a veterinary assistant. And according to this, is under direct supervision. The only leeway we were giving on the other motion, in my understanding, was for RVTs to be under either direct or indirect, under the discretion of the veterinarian with the VCPR in a range setting.
So if a veterinarian delegates a job to a veterinary assistant in a range setting, for instance, cold water washing a limb, and something goes wrong, does that mean the veterinarian is outside of the practice boundaries?
We're only talking about animal physical rehab. That's all we're talking about.
Well, if you go
Other
back
tests.
to your definition of animal physical rehab, is the treatment of injury or illness to address pain and improve function. Cold water washing is exactly that. In the horse world, that's what.
But I don't think that still fits APR.
But in a court of law, I think it might. I mean, we have to be very careful in that.
Washing horse is not.
I'm not talking about washing, I'm talking about a bone tendon that needs cold water therapy or ice therapy immediately. And we direct a veterinary assistant to do it because we're out on a call on some other animal. And if something goes wrong and the client goes to court with that, they can make an argument for that, in my opinion.
Well, I think the discussion is about whether or not, and correct me if I'm wrong, whether we should expand indirect supervision in the range setting for large animals.
The veterinarian that has directed a veterinary assistant to provide a treatment option in a range setting, is that veterinarian then liable for malpractice if something goes wrong and they are sued?
Yes.
Then I have a problem with it without adding the range setting, because I think a lot of large animal veterinarians are in a daily practice going to have to break that rule if they're going to do their work.
They're always liable for
Yeah,
their
they're
employees.
I know they're always liable, but I mean, are they going to be able to say that they knew by statute that they were not to direct a veterinary assistant to do that treatment? That's what I'm asking.
Right. I mean, this actually pretty much would maintain, I guess, in effect, existing law insofar as if a veterinarian is directing an assistant to provide APR, it's direct supervision. I mean, the whole request has been, the discussion has been focused on whether or not a physical therapist could provide physical therapy on animals outside of a veterinarian practice. And this specifies that it's still within the context of veterinary medicine. So the APR is provided by the veterinarian and then delegated to an RVT or a VA under either direct for only VAs or RVTs as determined by the veterinarian.
I think the veterinarian should be able to determine either one in the range setting. I think there are instances to correctly care for an animal, there needs to be some ability to do VA treatments under indirect supervision.
Yes, and I think part of this is the definition of APR, because I think, you know, if a horse had sustained a laceration and you instructed your veterinary assistant to apply ice to the wound, yes, it's a treatment, but that's not animal physical rehabilitation. You're treating a laceration with the use of ice.
Okay, well, where does that, I mean, the definition is so broad that it really doesn't define that clearly in my mind, so I think that's a problem. So,
We did try to, we went down that avenue years ago of defining it very specifically and got into a lot of trouble of doing that. And the first job of the task force was to define it, and it was under, advice of multiple people to keep it more open so that we weren't restricting people from exercising animals for doing other types of activity that truly didn't fall under animal physical rehab. So it is meant to be open for interpretation, and that's the problem with writing regulations. And so you either define it really, really narrow and are stuck with it, or you make it more broad where there is room for interpretation and work.
Could you,
Catherine?
I don't know if this solves it, it probably doesn't, and I'm not even sure we can do it, but if you added in D, veterinary assistants may perform APR under the direct supervision of the veterinarian or in a range setting at the discretion of the treating veterinarian. Is that what you're talking about, Jeannie?
Yeah, I guess that's what I'm talking about, unless somehow you want to not define, you could define first aid versus APR. I don't know, because I think most of it is treatment that needs to be done fairly acutely, right? It's something that is urgent. Yes, I guess.
Jennifer?
I remember having this discussion each time we did, and I can definitely appreciate the danger horses pose. I've had horses my entire life. I've sustained several injuries. But I remember in the discussion, I can't wrap my mind around cold water therapy being the practice of APR, and that's the definition. I think that's where there was some ambiguity in it. So,
Nancy?
There's a bigger problem than that, and number one, range setting is not defined in the Practice Act yet, and perhaps, I think I've seen some proposals to include it, but it is not included, and unless you also are planning to do that, this doesn't matter. And number two, 2036 doesn't allow a veterinary assistant to work in anywhere other than an animal hospital setting. So you need to amend 2036 as well if you're going to allow. And apparently, veterinary assistants are working outside of animal hospital settings with large animal veterinarians all the time, but it's all illegal currently because 2036B says that a veterinary assistant in an animal hospital setting may perform auxiliary animal health care tasks. So that's something that needs to be addressed before you can possibly allow a veterinary assistant to do anything in a range setting.
Thanks.
The 2036, it's not in 2036. I think what is being referred to here is 2036.5. And it does talk about permit holders and veterinary assistants in an animal hospital setting. It really comes down to defining what an animal hospital setting is. So, there's been some proposals to change that. As far as the range setting situation itself, it is described as general vicinity, which is very vague, but it is in the Practice Act that a range setting is where the veterinarian is in the general vicinity of the treatment area. So I did want to respond to that, and I believe that's been applied as, within 30 miles or 30 minutes in the past. For the purposes of this discussion, I feel like we continue to repeat the same discussion meeting after meeting after meeting. We had this very discussion in July. And I respect why you're bringing it up, but it was discussed in July. The minutes are reflective of what the board's motion was. I don't know at this point. I do want to bring up that this definition of animal physical rehabilitation was not crafted by the Veterinary Medical Board. This came out of the Animal Rehabilitation Task Force. And this definition was worked on by public members, licensed veterinarians, RVTs, physical therapists, consumers, counsel, and I believed at that point in time that this was the most complete definition that we could come up with without excluding things that were in fact problematic to allow an unlicensed individual to do absent some form of supervision. If there is middle ground to discuss veterinary assistance in working with under the direct supervision of a veterinarian, or where the veterinarian is in the general vicinity of the location for a large animal, that's another discussion, but I think we continue to have the same discussion meeting after meeting, and at some point we just need to decide whether or not we're going to go forward with this and let the public comment on this regulatory provision and allow people to weigh in on this very issue. And is it going to be confusing to the public? Perhaps the definition isn't where it needs to be, but I think we're going to get that input as we go through the regulatory process.
Is there a motion on the floor?
Yeah, you motioned and Jennifer Laredo seconded the motion.
To adopt.
Any other comment? Any more comment from the public?
Good afternoon. James Sims, California Physical Therapy Association. Kind of a point of clarification, first of all. I think it's inaccurate to describe this proposed regulation as coming out of the task force.
The definition did.
Let me finish. And it appears that, the cherry picking of the recommendations of the task force it occurred at a meeting in Oakland, where certain parts of it was accepted. I think this board owns now the responsibility and the language of what is here. A couple of times it's frustrating as a consumer also that public comments received by this board sometimes appear to not have been heard very well. It's just that the Sunset Review Board asked for this formulation of the task force when it became apparent to them that maybe some of the other interests, stakeholders, and to me that's my opinion, the genesis of, in my understanding, the genesis of the Sunset process, having that task force formulated, and then again in Oakland, having it followed to some degree and not to a lot degree. And we're back to deja vu again, as Dr. Grant said, back in Oakland, as we go from there. And it's a challenge for this group here. And so I just want to make sure that we recognize where this has come. It's been a long time for a few of us that have tried to look at this and find a resolution, and we're kind of we're at where we're at now. So, thank you.
Thank you. Any other comments from the public? So, we have a motion and a second. Call for the vote.
Okay, Dr. Waterhouse,
Yes.
Dr. Sullivan,
Yes.
Kathy Bowler,
Yes.
Jennifer Laredo,
Yes.
Dr. Nolan,
No.
Dr. Nunez,
No.
the motion still carries.
Motion carries.
5-2, Tara, since we're missing 2 members. Yes, 4-2, I'm sorry. 1, 2, 3, 4, I think, yeah.
Let me take a look at the admin manual real quick.
I'm going to read the motion again, in case we're in a position that we're moving this forward. Tara's checking the manual on a 4-2 vote with 2 members absent. The motion is to approve, and there are no amendments to the language presented today. The proposed regulatory changes direct the executive officer to take all necessary steps to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day public comment period, and if no adverse comments are received during the comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
All right, so according to the board's administrative manual, when there are 6 or more members of the board present at a meeting, the concurrence of 5 members is necessary to constitute an act or decision.
So this does not carry.
Correct.
Okay.
Would you like another proposal? Would you like another resolution?
If you care to make one, you can make
You can make it the motion you want.
No, I'm afraid it might be redundant, honestly, but, so just feel free to correct me if I'm wrong. But if I were to add behind 2038.5D, veterinary assistants may perform APR under the direct supervision of the veterinarian, or in the event of an emergency treatment, or an event of emergency. I mean, I'm thinking of the large animal vet that goes out and with grass tetany or magnesium. I mean, you have multiple animals, cows, horses, whatever. You have to use your veterinary assistant. You can't, I mean, there's things that they have to do.
But this is just APR.
Well, I'm afraid in the large animal world, APR is very muddy. We do a lot. Okay, so I feel like this board is thinking very strictly about the small animal world and not really considering what the large animal veterinarian does on a day-to-day basis. That's what I think. And so I feel like if I were a large animal veterinarian and I read this, I would feel very uncomfortable that I would be practicing medicine outside of this statute. That's how I read it.
Okay, so your motion is?
I don't know. Help make a motion. I'm just saying, I feel like it's not really considering what the real world is for a lot of our veterinarians that practice, the large animal veterinarians. And
Jennifer?
I have a question, maybe Dr. Nolan can help me understand, because I have a very narrow scope. When I call my veterinarian up to my home to check on my horse, he gives me instructions as the owner, not as the RVT.
Right.
And in an equine hospital, there are interns around, veterinary interns.
and assistants.
And that was my question, is where would we have a situation where assistants would be performing these tasks without any
Well,
supervision?
changing wraps would be one thing, cold water therapy, putting a horse in a saltwater, pardon me, I'm having a brain freeze, in a treadmill, probably considered therapy. It's not, it's fairly exacting, you have to know what you're doing. But again, if you can train your veterinary assistant to help you with that, I think that it's realistic. So would you consider putting a dog in a saltwater treadmill, do you do that with dogs?
An underwater treadmill?
Yeah.
Yes, I consider that part of, but just changing a bandage, no.
Okay.
Doing ice packs, no.
Okay. Good.
Again, it, I think, reflects back on the function or the task. If it is a horse that is undergoing normal exercise therapy for its running procedures, I think that's much different than the treatment for a medical condition. I think a lot of it is semantics, and I do agree the purpose that we consider the range setting different is that the population is different. The health needs of the small animal patient is greatly geriatric, whereas in the equine business it's more athletic. I think the risks are different, but I don't know how to write that in regulation without losing the teeth in it. I don't know how to do it.
Yes, Val.
Valerie Fenstermaker, CVMA, maybe the longest running person in this topic, as long as I can remember almost. But in the interest of moving this forward, I would suggest you look at the MSM language because it is an existing regulation, and it reads, at the time a chiropractor is performing MSM on an animal patient in a range setting, and I realize there is not a definition of range setting, however it is in here and there are efforts to define it. The supervising veterinarian shall be in the general vicinity of the treatment area. It's in regulation. If you're going to go down this road, I would suggest you at least look at what's already there.
What subdivision were you looking at?
2038 C. 2038 C. It's the second sentence.
Which is, I think, what I suggested when Nancy brought it up, is that there is a model for that. One of the challenges that we may face with that is, and we didn't face it at the time MSM was adopted, is, and this is something we'll just have to deal with if that becomes an issue, is the Office of Administrative Law may require us to define general vicinity. So, I mean, there are some hurdles because it is vague, but it's what I read earlier. So this is not an indirect supervision model. That, I think, is what Val was pointing out and what I think that bears discussion. It's direct supervision, but they have to be in the general vicinity. So it doesn't change the supervision protocol. What it changes is the setting that you're in. So if there's a little more comfort in that it's still required to be direct supervision, but if in a range setting, the veterinarian may provide that level of supervision in the general vicinity, that is an option.
You want to amend your,
Go ahead and make the motion.
I move that we approve the language, the proposed language, with the exception of adding to 2038.5D, veterinary assistants may perform APR under the direct supervision of a veterinarian. Now, would you do that?
Or if in a range setting, the veterinary assistant is performing APR on an animal patient, excuse me, let me restart that.
Yeah.
Veterinary assistants may perform APR under the direct supervision of a veterinarian. At the time the veterinary assistant is performing APR on an animal patient in a range setting, the supervising veterinarian shall be in the general vicinity of the treatment area.
I second that.
Okay, I have a motion and a second. Any other comments from the board? Any comments from the public?
I don't really object to that, because that is the definition of direct supervision. What I still like to reiterate my point that veterinary assistants are not allowed to work in a range setting unless you write a new amend 2036B at the same time.
They can in direct supervision.
Under any supervision, subject to the provisions of subsection A of this section, permit holders and veterinary assistants in an animal hospital setting may perform auxiliary animal health care tasks under the direct or indirect supervision of a licensed veterinarian or the direct supervision of an RVT. Doesn't say anything about any other setting other than an animal hospital setting.
Well, I would refer you to 2034G, which says it defines animal hospital setting to mean all veterinary premises which are required to be
Exactly.
registered with the board, which could effectively be a
It
mobile.
could be arranged.
Okay, a mobile.
Or a
that
mobile
was- so
practice.
A mobile practice. So if the veterinarian is present,
Yeah.
then it's okay.
Well, they have to have a premises permit in order to be an animal hospital setting.
Okay, so they cannot work, they could not do it under indirect supervision. If the veterinarian was not present in the general vicinity, then it would not, there would be no mobile, there would be no premise permit. The premise permit goes with the veterinarian.
But the veterinarian takes his mobile practice with him to the range.
Yes, so as long as the veterinarian is there.
Right, that's the idea, yeah. I mean, that was what I thought we were doing.
Yeah.
That's good.
I just have a comment. The way I look at 2036 and these other new regulations is that you're adding tasks that a VA can do. I don't have any problem with 2036 because to me it doesn't say that a VA can only do these tasks in an animal hospital setting. And I know that there's proposed new regulations that will clarify that, but in the meantime, I think from a legal perspective, this just adds something, and I think we need to always look at all the regulations in the Practice Act sort of taken as a whole. And again, there's nothing in 2036 that says that a VA can only perform animal health care tasks in an animal hospital setting.
Thank you. Any other comments? Okay, we have a motion and a second. We'll call for the vote.
I think she had a comment.
Oh, did somebody?
I have a question. As an ambulatory vet and having come from a rural area where I grew up, the question is how can we, in the general vicinity, when you may have a 200-mile diameter practice area, how can we be in the general vicinity? You know, somebody might be out preg checking cows and doesn't even have cell phone access in a more rural environment. You know, so I think, again, to go back for the veterinary assistant to be able to provide an AR in a range setting, and direct or indirect, you know, puts the onus back on the veterinarian to be sure that person is qualified. You know, and then if it is a general vicinity, how do I know how far away I can be?
I do need to caution, we don't write regulations for every situation. We write regulations as a general rule. And so it would not be appropriate for the board to tailor regulations to each and every situation. It may require more oversight than what you've done in the past, but I think this allows for flexibility for those individuals to be treating horses while you're not in line of sight or in a facility or, you know, directly overseeing those services that are appropriately delegated to a veterinary assistant. And you as a veterinarian decide the degree of competency of the individual that's providing those follow-up services for you. So again, I just want to make that statement that it would not be responsible for the board to write regulations to tailor something to individual situations. It needs to be applied as a whole. And as I stated, through the public comment period process, if we find that there is enough public comments from the large animal medicine world that this is not a workable solution, then the board's going to have to revisit this. That's why there is a public comment period. I think where we struggle is that we're getting hung up on trying to write language that suits every comment that comes before the board, and that's not the way regulations are written. I respect, the comments, and I appreciate the input, because I think it's something that we have to look at. That's our job, is to take into consideration, is this really a workable provision that provides the type of consumer protection that we need for something we consider perhaps has a degree of risk associated with it, that we're calling it out separately than other tasks. And our job is to take in the public comment and to evaluate that. But I think we have to start somewhere, or we're not going to get to the point where we're actually noticing this and taking in that input from the general public.
Nancy?
Just one more comment. I recall back when we were actually writing the definition of direct supervision, this came up about what does it mean in a large animal setting. And the discussion was that the general vicinity meant that the veterinarian was available should something come, an emergency arise, so that they were not going to be so far away that they couldn't come back and assist the RVT or the assistant if there was an emergency. That was, that was the best that people could come up with.
Mm-hmm.
Okay, we have a motion and a second? Yes?
I'm just James Sims, California Physical Therapy Association. If I can have the motion, this motion that is being considered.
The motion reads as follows. Veterinary assistants may perform APR under the direct supervision of a veterinarian, period. If at the time a veterinary assistant is performing APR on an animal patient in a range setting, the supervising veterinarian shall be in the general vicinity of the treatment area.
Okay. A vote was taken 4-2, and 5 needed to carry the noticed regulation in the agenda. And now there's a vote on something that I'm wondering if it's in order, because it wasn't agendized, and that was
It is
done.
appropriate. We have counsel here that will
That's what I'm
notify
asking.
the board.
I just want to,
Yeah.
because I don't want to.
Jerry, do you want to
Just from
discuss
procedural
the
things,
issue?
yeah.
I don't
It's the
think
same
that-
issue, it's on the agenda.
When I read what's agendized, it is add 2038.5 to the CCR regarding animal physical rehabilitation. There's language here that the board can vote on, and as long as they're talking about animal physical rehabilitation and adding section 2038.5 in whatever context and with whatever revisions come out of this discussion, as long as the board is voting on that, which they are, that doesn't fall outside
Okay, just
of
wanted
the agenda.
Not have it kicked down the road. Valerie's the longest, I'm the second longest, then kicking this can down the road, so I just want to make sure we're good in that, so, thank you.
Thank you.
Any other comments from the public?
Tara, can I ask a procedural question? The motion was amended, a new motion was presented, it wasn't amended. Dr. Nolan made the motion, Dr. Sullivan seconded the motion. The motion included the language to approve this as amended. Do I need to read this entire text again?
The 45-day?
Yeah.
Yes.
Oh, boy. Okay. You can all sing along, since we probably all know the tune by this point. The motion is to approve, as amended, the proposed regulatory changes, direct the executive officer to take all necessary steps to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day public comment period, and if no adverse comments are received, which I doubt will happen, during the 45-day comment period, and no hearing is requested, adopt the proposed regulatory changes as modified.
Okay.
Should I call it?
Call for the vote.
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez?
No.
Okay, so now we have our 5-2.
5-1.
My math is great. 5-1. Carries. Motion carries.
Moving on to 6B, number 5, regarding drug counseling.
Sure. So now we're going to talk about drug counseling. And this came out of the MDC. This was a recommendation by the MDC before the Veterinary Medical Board to consider this language. Many of you know the history, so I won't bore us to tears with explaining where this all came from, but it was a legislative bill. It was in SB 546 originally, and there was quite a bit of negotiation by the sponsor of the bill, the committee, the California Veterinary Medical Association. I was representing the medical board, not the medical board, the Veterinary Medical Board during these negotiations, if you will. And we've taken in quite a bit of public comment on this regulatory provision. And so this has been, I think, pared down to something that would be very useful. I do believe that there's a couple of questions that the board may have on some of the language to get clarification, but this has been a long road to come up with a proposal that essentially requires veterinarians to provide, or at least offer to provide, whether it be an oral consultation or something through electronic means, but information about drugs being dispensed to their animals. And I will stop there.
I had a question on A, number 1, the name and description of the dangerous drug. When you say description, do you mean the type of drug? Is it an antibiotic or an anti-inflammatory, or what is the meaning of? So, yeah, John, maybe Dr. Klingborg, maybe you can come.
I'll make my way up there.
Do you mean that, or do you mean it's a white pill or a brown pill?
The format, the milligrams of the pill, is it a tablet, is it a pill? Those are description. Color of the pill.
50 milligram pill, is that
Yeah.
what you're, okay. Any other comments, questions?
I have a question, when you don't go where to go. Any special directions? What does that mean? Special directions for proper use and storage?
That might be, don't take this drug with prednisone. Don't take these two drugs at the same time.
Okay, that would be the common adverse effects.
Well, not necessarily. I mean,
necessarily.
it could be take with plenty of water, give with food as a special direction. That's not an
Okay,
adverse
okay,
effect.
thank you. Okay,
Don't take with dairy, that's common.
okay,
Yeah.
thank you.
I move that we accept this language for regulation proposal.
I'll second. Second. Any other questions from the board? Any questions from the public?
I know you've worked hard on this, so I'm sorry, but there's just some vague terms here that concern me as someone who is involved with enforcing it through my clients. The first question I have is 5B, because I was questioning description, but you responded to that. 5B, where it says, if requested, a veterinarian shall provide drug documentation if available. What kind of documentation are you referring to?
Dr. Sullivan wants to handle this.
This is if there's some extensive explanation needed and the person wants it in writing, we can go to any online service and provide that documentation. Briefs, what is that? Plum Briefs has very good software on providing that for client information. So it means if they request some documentation, we need to provide it.
So that could be just a page from Plum?
Yes.
Okay. And then I just would suggest that maybe, just to keep this in legal language, 5D, where it says, "It shall be noted in the medical record if a consultation is provided or refused," I would say declined, because we use the term declined. Because usually they decline, they say no, they don't really refuse. Okay, that was it. Thank you.
Any other comments from the public? Dr. Sullivan?
I just move to, I guess, amend the motion to remove refuse and put in decline.
Okay.
Okay.
And who's?
I still second.
Okay.
Any other comments from the board? Call for the vote.
Well, I have to read this horrendous thing.
Can I?
You want, here, Mark's gonna read it.
The motion is to approve, as amended, the proposed regulatory changes as modified, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notify the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
Okay. Thank you, Mark. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez?
Yes.
Thank you.
Motion passes.
carries.
And going to 6B, number 6, regarding emergency animal care.
All right, so this again came out of the MDC, and when the MDC requested that council and I work together, and Tara did an exceptional job reordering this, part of the request from the MDC was to actually put this language in order of the types of emergency care services that an RVT could in fact render without the veterinarian on site, and it could be done under protocol. And so the section itself has been reordered. So, you know, application of tourniquets and pressure bandages, resuscitative oxygen procedures, those, what we would consider life-threatening or life-saving treatments, are itemized ahead of subset B, which essentially says that the RVT would have to have direct communication with the veterinarian in order to administer pharmacological agents to prevent or control shock or parenteral fluids. I don't know what that is. Administration of drugs. Oh, that's an IV. Okay. Administration of drugs or drugs to manage pain or to sedate an animal for an examination or to prevent further injury. So there is a provision here that says if direct communication cannot be established under subdivision B, that the RVT can perform the task under written instructions established by the supervising veterinarian. Or in the case of a sanctioned rodeo or other sporting event, the veterinarian charged with the responsibility to provide the treatment to the animals at the rodeo or event, meaning that they can have direct communication with maybe not their supervising veterinarian, but the veterinarian that's been sanctioned by that sporting event or the rodeo to provide to render emergency care as needed. That veterinarian can, in fact, commission the RVT to provide drugs to sedate or to administer other pharmacological agents to prevent shock. So this again came out of Sunset Review, part of it did, in that we were asked to explore the option of changing regulations to allow RVTs to provide a certain level of emergency care at rodeos. So that's what the impetus was for this language before the MDC. In reviewing this language, we also discovered that this really does help certain situations in shelter settings where emergency care may need to be rendered in the absence of a veterinarian, but can be done safely and effectively under written protocols or through direct communication.
Why is that last sentence there? It says, such veterinarian shall be authorized to practice in the state.
Yeah, what
Is that in reference to the
That came
rodeo?
from, it came from subdivision or paragraph A2. So if you look at the proposal, we're striking 2, and at the very last sentence of that paragraph is such veterinarian shall be authorized. Initially, that referred to the employing veterinarian. So now it is the supervising veterinarian, or in case of a sanctioned rodeo,
So
the
this,
veterinarian charged. So
this
such
veterinarian
veterinarian.
is referring to the rodeo?
Yes, so that last sentence is qualifying the veterinarian charged with responsibility to provide treatment to animals at a rodeo or event. Such veterinarian shall be authorized to practice in the state. So this prevents essentially, let's just say either a rodeo or a dog show from having a veterinarian there who may be from out of state, who's not licensed to practice in California. That veterinarian could not be charged with responsibility for
I
the
understand
RVT.
that, but the way it sounds is that this is some sort of authorization of reciprocity, right?
Yeah, why don't we just say licensed?
It's saying that, it sounds, the way it's written sounds like we're granting that veterinarian a license to practice in California. I know what you're trying to say, but the way it's written, it sounds like you're granting them a license, a provisional license.
So we could simply change that last sentence that says, or in the case of a sanctioned rodeo or other sporting event, the licensed veterinarian charged with responsibility to provide treatment to the animals at the rodeo or event.
Or the veterinarian shall be a licensed California veterinarian, something like that.
Okay, so do you want me to change authorized to licensed? The veterinarian shall be licensed to practice in the state?
That sounds better to me, but Dr. Solon has a question or point.
Is there not a situation where we may have a disaster and out-of-state veterinarians could come in that aren't licensed but are authorized?
That's something different.
That's separate.
Yeah.
Why is that separate?
This isn't a disaster.
This is
No,
in regards to
but
what
you're going to
Yeah.
have veterinarians in a disaster
this is in regards to
situation
what
where
RTs can do.
they're authorized to practice and a technician working under there. Is it all, I thought we were trying to make this more broad so that technicians could operate under the direction even outside a rodeo.
Yeah, they can. It doesn't, only the last part of it qualifies the rodeo where it talks about a supervising veterinarian versus a veterinarian employed by an event to provide oversight or care. So that last sentence qualifies that veterinarian as being someone that has to be essentially licensed in the state. I think we had authorized to practice because we were trying to figure out whether there would be any exempt settings, but there's really not any exempt settings. John?
Well, we didn't license.
Olympics? I think we're going to take care of that in statute.
I'm not sure that you need that last sentence because in the previous page, we talk about the following tests shall only be performed after direct communication with a veterinarian license or otherwise authorized to practice in the state.
Mm-hmm.
And I think we could potentially consider striking that final sentence because the veterinarian's already authorized.
Yeah.
Just strike it.
And
Okay.
that is there because of disaster situations.
Okay.
comments from the board? Is there a motion?
I move that these regulations be moved forward through the regulatory process.
With the amendment.
As amended.
As amended.
As amended? And I'm sorry, was there a second?
Second.
As for-
Any comments from the public? That's fine.
Okay, now I get, oh, there's
No.
I just have one question. On section C, the last page, who is that supervising veterinarian? That just confuses me as far as supervising, because you're talking about how they can perform tasks after direct communication with a veterinarian licensed or otherwise authorized to practice in the state.
Right, but if they can't directly contact the supervising veterinarian, they can work under the supervisor veterinarian's protocols. RVTs can work under a supervising veterinarian's protocols. Really, at any given time, they're doing something that requires only indirect supervision. But the difference is there's a veterinarian that may be employed by a rodeo or a sporting event that may not be that RVT's supervising veterinarian. This gives the flexibility that that veterinarian that's charged with oversight for that event could also be the one to establish those written protocols.
Okay, and I understand that part, because that's the second part, but I still don't understand where these protocols, I mean, this is an emergency, so I don't understand who wrote these protocols and how the RVT acting in that emergency circumstance happens to have protocols. I mean, where
So
do
for
those
a
protocols come from?
rodeo event where the veterinarian may be on call because that's more of a typical standard, the RVT would be on site and would be working under protocols.
No, and I understand that. I mean, I used to show dogs, so I get it. I'm talking about before the or, because it says or in the case of a sanctioned rodeo or other sporting events. I'm talking about the part before the or, which says that in the event that direct communication cannot be established as required under subdivision B, the RVT may perform the task in accordance with written instructions established by the supervising veterinarian, or in the case of a sanctioned rodeo or other sporting
Shelter
event.
medicine. Shelter medicine. They're operating under protocols all the time. But they don't have the authority to sedate an animal.
No, and I understand that. I guess what I'm getting at is the or says that this is a different circumstance. So the or means, if you're talking about a rodeo or dog show, what is the situation before that when there's emergency and you have written protocols?
The shelter medicine.
No, I think what she's trying to say is, I mean, I can't, an RVT is working for somebody.
Right.
And so, I mean, I think what you're saying is, if the RVT is just walking down the street and not employed by anybody and comes across an emergency situation, you're asking which written protocol they following. Is that what you're asking?
Pretty much. I mean, in other words, you're allowing the RVT to perform these tasks either after they've had direct communication with a vet or based on protocols set up by their supervising veterinarian. But how many supervising veterinarians have set up random protocols?
Because, I mean, the section does start out, emergency animal care rendered by a registered veterinary technician. And then it says ABC, and C is, so if you say C, emergency animal care rendered by registered veterinary technicians, C, in the event that direct communication cannot be established.
I don't see the issue. This is all under statute. In 4840.5, it provides for the authority of an RVT to administer emergency medicine, and it says, may render such life-saving aid and treatment as may be prescribed under regulations adopted by the board pursuant to 4836. Such emergency aid and treatment, if rendered to an animal patient not in the presence of a licensed veterinarian, may only be continued under the direction of a licensed veterinarian. Emergency, end quote, for the purposes of the section, means that the animal has been placed in a life-threatening condition where immediate treatment is necessary. The current language says to sustain life, but there's a bill that has, I believe, been signed by this point where that to sustain life was removed. So it basically ends with condition where immediate treatment is necessary. This serves to qualify what's in statute.
So I understand that. I mean, I understand the purpose of it. I still think that from a point of view, from my point of having to explain it to somebody or to defend it, I'm very confused because it says that the RVT has to have direct communication, and then skip the next part because that's the one that confuses me, or if they're at a horse show or a dog show or a rodeo or whatever. So those are those two. So there's three circumstances: direct communication, written protocols from a supervising vet, which I don't know kind of where that comes from and who that supervising vet is. Like, what if this person happens to be just walking down the street or involved with a situation where there's a car accident or something? Well, I'm not even talking about drugs. I mean, I'm talking about what they do here is...
But this is the administration of drugs. So I think...
I'd also like to just
There's
point out
wound
that
dressings and other things in here. It's not just drugs.
No, it starts with subdivision B. The following tasks shall only be performed after direct communication with a veterinarian licensed or otherwise authorized to practice in the state. B goes on to talk about 1 and 2. And then C says that if you cannot establish written protocols are already in the Practice Act in other areas. So I guess I'm struggling with what's confusing about this when there is a precedent for that in the Practice Act for shelter situations, which we talked about at length yesterday.
Yeah, I'm not arguing the written protocols. I'm arguing, like, where do these, are these something that exist? Like, that's my problem, is putting my arms around. Are these things that exist where the RVT knows how to put their hands on them? You know, are they something that exists from this supervising veterinarian in the sky that are there?
yes, they would exist because this language is actually existing law. We're just moving it from where it currently sits. So today, if an RVT needs to act without direct communication, they can proceed under written orders.
That's only in the shelter situation.
No. That's in 2069 right now, without this proposal. All this proposal does actually...
I understand that. I still think it's confusing from my trying to decide where those protocols come from and who the supervising vet is. Is that the person who employs the RVT?
Well, that's interesting you say that because we're actually deleting the employing veterinarian and inserting supervising because that's the consistent use of the supervisor. Sorry, the veterinarian, it's the supervising veterinarian, which could be anyone at the practice. It doesn't have to be a licensing manager, it just has to be the supervising veterinarian over the RVTs, whoever's keeping an eye on the care being provided.
But this is all indirect supervision, so this is a supervising veterinarian who's not there, who somehow wrote these protocols, and then the RVT follows the protocols. Okay, I still think it's confusing, but...
Dr. Sullivan.
I think maybe an example would be, and maybe I'm confusing things, but you could have a hospital policy, private clinic policy, protocol that when I'm gone between 12:30 and 1:30 for lunch, an emergency comes in and my RVT is there, she knows what to do with this emergency situation because there's a written protocol. I'm the supervising veterinarian. I've written this protocol. In an emergency, she can follow these procedures.
Any other comments from the public? Jamie wants to run from the board. Jamie's going to read this time?
Yep,
Okay.
Jane's reading.
The motion is to approve as amended. The motion is to approve as amended the proposed regulatory changes, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period, and no hearing is requested, adopt the proposed regulatory changes as modified.
Okay, Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Kathy Bowler.
Yes.
Jennifer Laredo.
Yes.
Dr. Nolan.
Yes.
And Dr. Nunez.
Yes.
Okay, moving on to agenda item number 7. Cannabis. And Tara is going to. Oh, okay, sorry. Before we move on, we're going to have a bathroom break. Let's come back at 3 o'clock.
Oh, okay. What are we on now?
Reconvene, and we are moving on to agenda item number 7 regarding cannabis treatment. And our counsel, Tara, has prepared some remarks.
All right, so in tab 7 is my memo on this issue, which provides more detail with respect to the explicit federal and state laws that come into play here. So I'm just going to provide an overview of the situation, which really is under both federal and state law. A veterinarian does not have any authority to administer, prescribe, dispense, or even recommend the use of cannabis to treat an animal, which differs from physicians insofar as they have at least the ability to recommend the treatment, which means having a discussion with the client or the patient to say, oh, you've got epilepsy, you might want to try cannabis for that issue. That's the recommendation. The patient then goes to a dispensary separate and apart from the physician. There is no prescription, and they then use the cannabis based upon the recommendation. In the veterinarian context, there's no authority to do that. So what my memo proposes is seeking a legislative fix, if they're so inclined, to first request a study from the University of California, which would be identical to that study performed for the use of cannabis on human patients. And if that study concluded that the use of cannabis is helpful to animals, then at that point, the board would want to consider recommending to the legislature seeking the authorization to recommend cannabis to their patients. So a recommendation arguably falls outside of the DEA registration because there's no prescription or dispensing of a Schedule I controlled substance. And the recommendation itself, not only could it be authorized by California through the legislature, but then the recommendation conversation could be First Amendment protection of free speech with the client, which physicians currently enjoy, veterinarians do not. So if you have any questions, I can answer that. Otherwise, I'll just leave it up to the board to discuss.
Yes, Anne Marie would like to make a comment.
Just one comment. Since this document, and I want to thank Tara for putting in a lot of time and energy to create this legal memorandum. Now that we've discussed this at a public meeting, this essentially waives any attorney-client privilege that we may have been we could have exercised attorney-client privilege with this document, but by means of discussing it in an open meeting, it becomes a public document, and thereby we don't enjoy the privilege of keeping it confidential. And I think it's important that the public is aware of the current status of the both federal and state laws as it pertains to cannabis treatment for animal patients. I do want to call out one distinction here, and that is at the recent Board of Governors meeting for the California Veterinary Medical Association, they too had a legal opinion or a legal document before their Board of Governors. And I think that the two documents are very much coincide in a lot of ways. However, in the Board of Governors document, the recommendation or an option was documented that would essentially allow for legislation to provide some protection for the veterinarian to dispense marijuana, and that is very tricky. We are not looking at some sort of legislation that would allow a veterinarian to dispense, because that's still a violation of federal law. And you hold a DEA license. This isn't about dispensing marijuana. This is about being able to have a conversation with your client, some discourse about the treatment that may be provided. So I want to make that distinction clear. We would not, as a regulatory agency, be requesting some form of protection for recommending, dispensing, or doing anything with a Schedule I drug other than having a conversation with our client about the alternative uses of marijuana and perhaps what they need to be aware of if they're choosing to use these alternative treatments on their pets. And I think that's a distinction that needs to be made.
Dr. Sullivan.
The other thing we have to keep in mind is that the law that was passed is for legalization of marijuana in people. It doesn't mention anything about pets, so there's another huge hurdle that has to be overcome down this road.
Dr. Nunez.
I found it a little bit interesting. Well, one of the possible board recommendations is the board may wish to recommend to the legislature that cannabis treatment on animals be studied in a manner similar to another study that was done for humans and performed by the University of California. So I didn't realize the University of California had to serve at the pleasure of the legislature. If the legislature wants something studied, the University of California has to study it. Is that true?
At the risk of putting you on the spot, would you want to come up and?
Well, I just said it is a constitutional autonomous entity of the study.
It is. Do you see it?
Budget.
So I think the legislature is still correct.
But they don't, if the legislature asks you to study it, you don't have to study it, do you?
It was funding.
I know you don't want to piss them off. Anyways, I thought that was interesting.
Yes.
Because they said, can we do that?
I think the legislature has directed San Diego State University to do some studying on the effects to essentially devise a formula for when someone is under the influence of, and how that would be essentially identified separate and apart from alcohol where you're using a VAC. So I believe it's San Diego State University that's doing the study now on impairment and what medicinal impairment looks like, or how you're impaired when you're smoking marijuana versus impaired drinking alcohol. And there are different markers and there are different ways to identify that. So that study was, I don't want to say, you want to call it commissioned by the legislature, but was assigned to San Diego State. And I think there's another study at UC San Diego.
I mean, in my opinion, is that actually is the only thing that I currently would support. I don't know if I would even support the ability for a veterinarian to advise, because they have no studies to base their recommendations off of, other than clinical experience, I suppose. And maybe I'm being both old-fashioned and Jeff Session-ish about that, but that's how I believe.
So at this point in time, are we even allowed to tell our clients if there's, discuss with our clients the topic to the point where, there is really no studies to confirm efficacy or dose or side effects or?
Well, I think in having the conversation with your client, you're saying, one, I can't recommend anything. Two, there's no research that I could rely on anyway. So really, the extent of the veterinarian discussion should be more about treating toxicity from cannabis exposure because of the proliferation of these products. Now that there's not only the medicinal use of it, but now we're also coming up to the recreational use. So, there's a great fear that more and more animals are going to be exposed to these items, and how does the veterinarian treat the patient when there's a cannabis toxicity? That, of course, would fall under your
I think we've all treated
existing,
cannabis toxicity.
absolutely,
Yes.
your existing authorization to treat the patient. But when you're talking about using a medication to treat an illness with a drug that's a Schedule I, and in this case cannabis, I would highly recommend the veterinarian stop the conversation. And with just, I can't recommend, and we don't know today the best use of cannabis on animals. So to clarify, the state commissioned a study of medical marijuana on the use of human patients through the University of California. So I guess you could just say it's a commissioned study rather than a directive to study.
So what Anne Marie and I had talked about was possibly a motion to propose legislation to allow research in California and possibly give some level of protection so veterinarians can at least discuss marijuana with their clients. So that's the question, is what do we do?
On the allow research, I think we have to be more determinative on who and what is the research and doesn't. Because there's probably plenty of people that claim they have research.
So through the University of California?
Yeah, I mean, so that, I think maybe that's why the stipulation was in for the humans.
I would be in support, would be willing to make a motion that we recommend to the legislature that cannabis treatment be studied in a manner similar to the study on humans performed by the University of California.
But do we know what the study is in humans? I don't know if I want to restrict them that way. Allow for.
When did these?
Research on the efficacy of the use of marijuana in animal patients?
Dose, side effects.
Side effects, yeah.
Well, would efficacy include those things if we just said a motion to allow research on the efficacy for using marijuana in animal patients through the University of California? I mean, the language is going to be rewritten by the legislature, so wordsmithing it's not going to do us any good. But if the intent of the motion is to allow for research to study the use of marijuana in animal patients or the use of cannabis in animal patients to determine its efficacy, its safety, its
indications
of use.
So when I read in the memo under possible board recommendations with respect to research, I note that the board could request the study be performed by the UC through the California Cannabis Research Program, and I provide the Health and Safety Code section that commissions the study for humans. And in that, it says, it's the intent of the legislature that the state commission objective scientific research by the premier, you'll like this, the premier research institute of the world, the University of California. I'm reading this for this purpose, regarding the efficacy and safety of administering cannabis as part of medical treatment. I mean, it doesn't actually limit it to humans right there, but I think they have limited it to humans. And it goes on to say, the regents of the UC, by appropriate resolution, if they accept the responsibility, the UC shall create a program to be known as the California Cannabis Research Program. So there is this legislative intent language already in the law. Effectively, the recommendation would be to piggyback onto this statute to perform research on the efficacy and safety of administering cannabis as part of medical treatment on animals.
And if we became part of that program, does it limit the type of studies that can be done? Well, in other words, maybe they're just studying cancer treatment or cancer side effects, or something that doesn't necessarily
So let me continue. The program shall develop and conduct studies intended to ascertain the general medical safety and efficacy of cannabis, and if found valuable, shall develop medical guidelines for the appropriate administration and use of cannabis. The studies may include studies to ascertain the effect of cannabis on motor skills.
Humans.
This intent language is really long, and I think, when I look at this overall, I see that their intent was to look at everything of the human condition when treated with cannabis.
Was that done after 215 was passed? Way back when, or when did the research commence? That was 96 or 98, something like that. But nothing was done for a long time.
I believe you're correct.
215.
It's related to 215,
Okay.
yeah.
It makes sense.
Dr. Sullivan?
Yeah, I think we're way ahead by approaching that for a couple of reasons. I think we need some basic research to identify what even the toxic levels are for different species. I think in human medicine they're beyond that to look at treatment. I don't think we're close to that. So I think we would have a difficult time talking about treatment when we don't even know what the toxic levels are. And I think there needs to be some basic science done initially. And to me, that would be easier to sell, because we're talking about treating toxic conditions, than it is talking about research and using it when we're in veterinary medicine, we're a lot further away than human medicine is.
But once they developed, the idea is that once they develop sort of a toxic level, then the next step would be to go check for efficacy for various problems. Yes, Kathy?
Am I correct, because of the federal problems here, that there have been no studies from any of the universities anywhere, other than it looks like Colorado did?
There's very few facilities that can do research on Schedule I drugs.
Right.
Very few.
And, okay.
Okay, so is there a motion?
I motion, like I said, to recommend to legislature that studies be done on the indications and efficacy of medical marijuana use in animals, and that study be done by the
World premiere.
world leading premier fabulous research
Or
organization,
facility in
also
the
known as
world.
the University of California. Specifically, the Dr. Pasco does the research.
No, I was gonna say, you can be more specific and say that the legislature shall commission the University of California, Davis to conduct research through, no reaction, through,
She's not listening.
he's not listening. So Davis is gonna do this. Okay, okay, we have a second.
Do we have a second?
Wait until he hears the motion.
I'll second that.
Did you hear anything we said?
You will.
I was thinking of a much simpler way to get it.
You're committed.
You're committed. You want me to read the motion?
You're studying marijuana.
Actually, it does say Dr. Pasco is studying. So there's a motion and a second from Dr. Nunez and Dr. Sullivan.
Any comments from the public? Would you see Davis like to discuss this?
Not really, I was just going to suggest that probably the easiest vehicle would be, since I was actually trying to Google this to see a little bit more about it, but it would seem to me that if there's a process already through this California Cannabis Research Program and it's through the UC, it would be to encourage the legislature to broaden the intent of it to include animals, but not for the purpose of just research on animals, but for a medical reason. Does that make sense? So maybe a much cleaner, easier way to get an amendment to that.
No.
Didn't make any sense to me. So as I understood what Tara has here, there already exists this California Cannabis Research Program.
Yes,
And
but
then-
we don't know if it's exactly would fit veterinary medicine.
Well, reading what I was just reading quickly, I don't think it does. It's restricted to human patients. But what I'm saying is that rather than recreate something, because there's a substantial amount of money that went to this, would be to carve out a piece of that for research in animals. So basically broaden it from humans to animals, humans and animals. Just an alternative approach.
Yeah.
Do you know what the status of this is? Is it completed, ongoing?
Shouldn't we find this out?
Yeah.
I don't know the current,
It looked to me like the quick look I looked on my phone that it doesn't, the appropriations didn't happen and it won't go into effect till 18. 18 or 19. So, you know, there's authorization, then there has to be appropriation, and it looked like there was another bill working its way through the legislature for appropriation.
well, so effectively, what you could recommend is amendments to Health and Safety Code, Section 11362.9, and which is the intent language commissioning the study, as well as any other relevant statutes within that article. It's Article 2 on cannabis.
That's the motion I seconded.
It is.
You guys work this out.
Okay. So what I hear is that the motion would be to amend Health and Safety Code 11362.9 to include research on the efficacy, safety, indications of use in animal patients under this California Cannabis Research Program through the University of California at Davis.
See, that's true.
Yes, but we don't really know what we're.
Well, yeah, it's pretty hard to, I mean, we don't even have that in front of us,
So here's another option. We meet again in February. We can actually provide you with these provisions
Beforehand.
and do some research on how far along this California
Let's-
Cannabis
let's-
Research Program is,
Let's do that.
what the actual language is or the direction for the research, and then we can talk about it.
Let's do that.
Fair.
Direct staff.
They want us to bring back information on Health and Safety Code 11.3.62.9 and also find out a little bit more about this research program in February.
And there would, yeah, and I agree, and there would be very many different protocols for multi-species research versus human research, so
And who
I don't know how it
controls that?
interfaces.
Well, perhaps we could get someone from.
We need to have-
the program itself to come in and give us a presentation on what they're doing
That would be great.
today, where they're at in the
Yeah.
research. Because otherwise, it's us trying to make phone calls and get, additional information, which we're interpreting. It's
Right.
probably best just to hear it from the program itself.
Is this a state-funded program then?
Yes.
We need a motion for that?
No.
Okay, we don't need a motion for that. I guess we're gonna do more research on this.
Can I read that statement anyway?
And I'd like to know if the people that control this program, if they'd even be willing to give up some of their funding to
Yeah,
research.
that's the
that.
thing.
So they may say, oh, no, no, no.
Right.
Maybe your own thing.
Yeah.
Okay, next. All right. Sarah, is there anything else you think we need to do, other than invite someone to?
No, I think it's, I've got the recommendations here in case you guys wanted to do something right now, because, I think there is some level of urgency with respect to the toxicity issues you're all seeing. But as far as treating patients, I think that necessarily requires a deliberative process, and bringing in someone from the current research program is a good way to help get the information you need to take the next steps.
Okay, we done with marijuana? Moving on to agenda item number 8. Oh, Kurt, yes.
I apologize, I don't want to be nosy parliamentarian, just I think we dispense, I think it was a motion and a second.
Oh, sorry, there was.
Just dispense with that.
You're right.
Perhaps it's easy if the motion maker and the second would just withdraw in face of
Yes.
the new staff directive.
Yep.
Withdraw your motion. You don't have to.
I could demand for there to be a vote, but I will withdraw it.
I would draw the second.
Who's the second?
It was Dick.
Okay, agenda item number 8, Dr. Klingborg with the MDC report.
Good afternoon, John Klingborg, MDC Chair. You should have my report in front of you. It's got animals on it.
Very cute.
Thank you. It does start with number 4 because it was the 4th item on the agenda. It was the first action item. So there's consistency there. The first 3 items were called to order, committee remarks, and review of minutes. So we started with 4. This was the thinnest packet I think I've had in my career at the MDC, and maybe the most difficult to make our way through. So it was deceiving. What you have in front of you in my report is a summary and kind of the main action items. I'll fill in a couple of blanks here. Our first action item, discussion, consideration of extended duty for registered veterinary technician regulations. We had a subcommittee that looked at some language that had been proposed to us through CARVTA, and there were a couple of elements to that. And I identified them as one recommendation that the subcommittee, that the VMB restrict to RVTs and DVMs any procedure that involves a needle penetrating a body cavity or blood vessel that would potentially limit access to veterinary care. And so that was one recommendation. The second was a statement by our subcommittee that a needle penetrating an epidural space is an invasive and arguably a surgical procedure with a great potential that potentially should be restricted to DVMs only. The third was that the induction of anesthesia by any means should be done by an RVT, just by any means. Fourth was casting and splinting to be performed by an RVT under indirect supervision. And then fifth was, again, a query, a discussion point by the subcommittee. Should animal health care tasks be modified to state the veterinary assistant should be prohibited performing invasive procedures, and how would we define invasive? So that was kind of a launching off point. What we did in all of that, then, our actual action items were in front of you. We did propose to amend 2036 Animal Healthcare Task for RVTs, and you will see that we have added the word general for B1, so it would read induce general anesthesia. And secondly, we removed apply casts and splints from a task that would need to be performed only under the direct supervision and moved it down under C, where it may be performed under indirect supervision by an RVT. So those were the 2 action items that came out of the 5 that I was speaking of. Next to the elephant there, just to orient you, we continued our discussion on epidurals and should they be restricted to DVMs only and or RVTs, and melded into that a discussion of local anesthesia, topical anesthesia, nerve blocks, etc. And then also a discussion is when is invasive, and what does invasive mean? Is invasive in the eye of the beholder? And what we decided we should do is take those other conversations, the penetrating of the body cavity, epidural, invasiveness, and really, instead of looking at it as a job tasks issue, look at it as duties of a supervising veterinarian. And maybe what we need to do is spend a little bit of time as we look at language in 2035.5, talk about risk, competency, training, invasiveness, what's happening in other states, what's the current standard of care for that particular job task, and try and see if we can't actually expand or clarify 2035.5 to help provide some guidance rather than getting into this laundry list, as we keep referring to it, of very specific tasks, some of which may become more mainstream and others which well, there's new ones all the time. So that was where we left that particular section of our agenda. Keep moving. Keep on swimming.
Any questions so far? Okay, keep going.
All right. Agenda item number 5, discussion and consideration of recommendations from SHAC and the CVMA regarding public and private shelters and minimum standards and protocols for shelter medicine. We had a subcommittee that went to work on this particular item. Dave Johnson and Jeff Pollard did great work, put together lots of information, really took information that had been provided to us by SHAC and CACTA and other stakeholders over a year ago now, or about a year ago, and provided us with a list of 8 specific areas where we needed to look at changing regulations or clarifying various aspects of minimum standards and protocols for shelter medicine. So we had 8. There was addition of at least 1 or 2 more in the process of the conversation, and of the 8, we discussed about 1.75. So,
could you be more precise?
We didn't even finish the second of 8. But they were very thorough discussions, and what we've done at this point actually is suggested that SHAC and CACTA, who did have a few other issues that bubbled up, take this back on at this point. They are the experts in this, working with our subcommittee, and then it's up to them in terms of what stakeholder groups they want to invite to their meeting, and then come back to us, hopefully in February, with some additional information so that we can move through this.
John, can I ask a question?
Yes.
For clarification, the subcommittee, is it still the same subcommittee at this point?
So I haven't changed the subcommittee yet, but I always, after a meeting like this, I always send a summary to the MDC about what we discussed, what our action items are, what new priorities the VMB has blessed us with. And at that point, I start to query for who wants to be involved on what subcommittee. And so I don't know if we're going to reshuffle the deck or not. I will chat with them. Okay. And so those are open discussions in a way. They're one-on-one between me and the various committee members. But that is a decision we'll make down the line. Soonly, though. Agenda item number 6 was a discussion and consideration of proposed statutory language regarding the veterinary student exemption. What you have in front of you in small print is language that we had previously discussed at the MDC and had passed through the MDC, had been discussed and passed by the board, and was taken to the legislature where it hit a bit of a wall. And the real issue was in paragraph B, where there were some concerns that language was going to create various problems for the universities. And so what we did yesterday was try and create some new language here that would satisfy, I think, a couple of the things that we really wanted to take out of B. And they were essentially that we want to have some transparency when a student is in part of their formal curriculum, but is not in a campus setting. So they're in a veterinary clinic that's an approved program of some sort. We want to have a written agreement of some sort of what that is going to look like between the clinical. We want the clinical training site to be approved. Let me not say written agreement. The clinical training site has been approved. The student has prior training in those activities, and the supervising veterinarian must be California licensed. And we felt that in making that addition, what that does is protect all of the classes of consumer, and that includes not just the patient and the client, but it protects the supervising veterinarian knowing what they should have, and also protects the student who's another class of consumer. And so 5A is now offered to you as a new language that we think meets the goals without being overly burdensome to the universities or raising red flags. Okay. And then item number 7, discussion and consideration of the California Veterinary Medical Association's proposal regarding minimum standards for alternate veterinary premises practices. CVMA had 7 long meetings and 2 years of them to hand us a substantially large packet, about as thick as our whole packet yesterday, with great regulations, but it was too much for us to absorb as a group. And what we're going to do, what we have done, is hand it off to a subcommittee who is going to sit there and look at it, because it's a jigsaw puzzle that's been rearranged. So I don't think there's a whole bunch that's new. There are some new things, but there's pieces that have been rearranged, and just understanding where they are and how they all fit together, and then have the subcommittee walk us through it, so we're not engaged in trying to write by group, but we can get some direction from them. And so that is what we accomplished yesterday.
Any questions from the board? Comments? Kathy?
I forget. What is an alternate veterinary premises?
So we've got the small animal vaccine animal vaccine premise, your ambulatory, small and large animal ambulatory premises, things of that sort.
Okay, thank you.
We are pleased to hear that the MDC feels blessed by our directives.
We do, yes. We serve at your pleasure, as you often remind us, Mark. Thank you. Okay.
Any comments from the public?
just to close in that, so the MDC, the priorities that still remain are the alternate premises types that will come back in February, as well as the shelter medicine issue. And because those are both extremely thorough and complex discussions, I think Dr. Klingborg and I felt that we would definitely be able to fill a day with those two items at this point, unless something comes out of the board. The rest of the remainder of this afternoon and tomorrow, those are the two MDC priorities that will move forward in February.
So the motion to accept the report?
So moved.
Second. Any comments from the public? Call for the vote.
Okay, Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan? It gets agendized for a future meeting. I don't think they're completely done with 2036 yet. Yeah, they're still discussing what to do with the invasive procedures part.
Agenda item number 9, update on the implementation of Senate Bill SB 27, which is the Antimicrobial Use Stewardship Outreach Committee. I know Dr. Nolan has worked on this, and Anne Marie is going to start off the discussion of this.
So in your packet, you have the letter that the Veterinary Medical Board, and it was actually the Executive Committee, which was the President and Vice President, wrote a letter in order to timely communicate with the California Department of Food and Ag about regulations. They were proposing on who can sell or dispense essentially an important antimicrobial drug. And of course, we have some issues that are outlined in the letter, primarily that it was a lay person who would actually be selling this drug. And for obvious reasons, the board has some strong opposition to that for safety reasons. There was a parallel made to, or comment made that, you know, the current practice before SB 27 was for these drugs to be sold from feed stores and other businesses that weren't pharmacies. And the whole point to SB 27 was to move these drugs under a prescription by a veterinarian. So having these drugs as a prescription, there are no other prescriptions that I'm aware of that can be sold by an unlicensed individual. So our comments were that these individuals don't have appropriate training, they're not licensed in the state, it's not under the pharmacy board, and therefore this raises some serious consumer protection issues, at least from our perspective. I also just want to clarify for you that I believe that the status of this regulatory provision is that they pulled some of this language, as far as I understand, related to this unlicensed individual being able to sell prescription drugs. I haven't seen the amended language yet. I don't know if Val has seen it. No, we haven't seen the amended language yet. But was it your understanding that they've pulled some of that language out? Unofficially, okay. So we will keep our eyes out for that. But I do want to also mention that if they do modify the language, we will only have 15 days within which to comment. So it would behoove the board to, again, you know, allow the executive committee that's already established in the board member procedurals manual that I am not on to comment on these regulations if we get this modified text that we need to respond to.
Dr. Nunez.
So, the proposed legislation says that these dangerous drugs and antibiotics need to be prescribed by a licensed veterinarian,
Right.
or a food directive, or
A veterinary feed directive.
feed directive,
Uh-huh.
and that these products can only be sold by a person who holds the veterinary food animal drug retail license. But the issue is that this license needs further clarification as far as drug distribution, quality control, safe storage and handling. That license is not clearly defined.
No,
Is that an issue?
No, the veterinary food drug retailer, beef fatters, they are licensed under the Board of Pharmacy. They're not the issue. It's this new classification that's within the regulation, which is the restricted livestock drug person or licensee, who is a person that has obtained a license for the purposes of filling these prescriptions. They are not regulated. Right, there's no training that we're aware of, and they're not licensed under the Board of Pharmacy.
I thought they've been licensed. I thought they have been in existence.
They have been in existence, you're absolutely right, but they were not able to sell prescription drugs because these drugs weren't by way of prescription.
Correct.
Yeah.
I also have a question. If they change it substantially, we have 45 days, don't we?
Well, the difference between a 15-day modification and a 45-day renotice is at 40, if they're changing the entire concept of the regulation or pulling back the intent of the regulation, they would have to start over again. But they can make quite a few modifications to this language under a 15-day notice. It just has to be substantially related to the intent and the text of the initial language. So I can foresee a lot of purview for them to do this under a 15-day comment period.
You will know where I am every 15 days.
No going to Africa.
And I am on the task force, by the way. Our next meeting is on the 27th of November. So,
Okay, so that's good to know.
yeah,
So we'll get an update on this language.
probably after that.
Yeah.
And was this aspect of it discussed heavily?
Not heavily, not yet. I think that our last meeting was actually quite a while ago. So I think that this is coming in, a lot of the details are coming in now, and a lot of public comment. So I assume it will be much more heavily discussed.
Also, just as a matter of FYI, I included at the end of all the regulatory documents, I included some information from the CDFA's website on the antimicrobial use stewardship page. And I just wanted you to be aware of some of the definitions that are out there today that CDFA, through their OS program, their antimicrobial use stewardship program, does float this information to the board through me and request review before these things get posted. For the most part, there are some technical things in here that they would not have necessarily provided to me in advance, but one of the areas that continues to come up as a struggle in terms of those that were pushing for some sort of oversight of the use of antimicrobial drugs, and it really starts at the bottom of the first page on antimicrobial use, is the regular pattern of use for medically important antimicrobial drugs. And there's some disagreement from some of those who perhaps were in opposition to veterinarians being able to make decisions on when to use these drugs prophylactically. In certain situations, the prophylactic use of antibiotics is still medically indicated, at least from the veterinary profession. There's some disagreement regarding prophylactic use and regular pattern of use. And so we're going to continue to struggle with that. The profession is going to continue to struggle with that. One area that's come up quite a bit in meetings that Val and I have been in is when you're transporting cattle intrastate or interstate, and there is some protocol to perhaps treat the cattle before transport to try to prevent the spread of infection. And there's some European models that they don't use antibiotics, and so there's some disagreement on whether or not that's regular pattern of use or whether that's medically indicated. And I think we're going to continue to struggle with that a little bit before we find some common ground.
So,
Does this board need to take any action concerning the letter that we wrote?
No.
Okay.
No, because you as an executive committee can engage in the rulemaking process in that way.
Okay.
I guess from the extent that you will also need to be available to provide comment during the 15-day comment period, the board could, by motion, approve the executive committee to continue to function in this capacity, but I don't think you need to because you're already established to do that.
Okay.
any other comments from the board? Any comments from the public? Well, since this is just an update, there's no motions here. So let's move on to agenda item number 10, the legislative report. And Anne Marie's going to talk about SB 547.
Okay, so you all know what's in this bill. This is basically a bill that provides some cleanup language for us on modifications of penalty. It also provided the board cleanup provisions related to address of record, which means that a licensee can have both a public forward-facing address and a private address on file with the board for purposes that we may need to keep someone's address non-public. And this allows us to have both, a public-facing address and a private address. So those were our provisions in SB 547. And I didn't get a chance to look, admittedly, as to whether or not the governor has signed 547 yet. Is anyone aware if it's actually been signed? Okay, Kathy can look. Moving on, and then we can go back. It was signed. Okay, thanks, Beth.
Signed.
So that one has been signed.
And the next two have been signed.
The next two have been signed. SB 673, that, and it's okay if we cheer, that the Pet Lover Specialized License Plate Program has now been moved under the California Department of Food and Ag. That was signed. No one cheered?
Wait, is it signed?
Yeah.
Okay, good. Yeah.
Okay. And AB 485, which was essentially a track bill, that was signed by the governor. I can go back and review any of these that you'd like me to, but it wasn't one of our initiatives. AB 942, veterinary personal income tax, that one didn't move forward, and it actually was suspended at our last meeting. So nothing more came of that bill. And then finally, we have a bill that you haven't seen before, and I don't know if the governor signed AB 208.
He did.
He did, oh my. Okay, so the governor signed AB 208. This is deferred entry of judgment, pretrial diversion. As a consumer protection board, I'm a little disheartened by this because essentially there's no conviction on record by which the board can take any action if the individual goes into one of these pretrial diversion programs. And my concern, oh, go ahead. Sorry.
Has been allayed because of amendments made to the bill, I think maybe in September. So the goal of the bill was to address individuals who were going through the diversion program but had to, in effect, plead guilty or nolo contendere, and that guilty plea was being used against them for immigration purposes. Mm-hmm. So to modify the wording, allow the deferred entry of judgment, this bill changes deferred entry of judgment to a pretrial diversion program where the individual pleads not guilty, goes through the diversion program, and then it's wiped clean, their record is. However, with the recent revisions to the bill
That were post September 8th? Or were those the revisions on September 8th?
I've got the history here. I don't know if it really matters.
Oh, you know what, I think, yeah, the last amendment was September 8th. And that's the version we have in our packet. So if those of you who are following along, it's under tab E.
Well, in any event, the language now actually refers back to Business and Professions Code Section 492, and makes explicit that the record of the allegation can still be used by the professional licensing board.
Yep.
For denying a license or taking other disciplinary action against the licensee. It's interesting because that language doesn't currently exist under the law. It's specifically Penal Code Section 1000. Those PC 1000 convictions have largely been viewed as wiping the slate clean. BPC 492, however, it says that there aren't any penal code sections that can keep the records away from a professional licensing board, healing arts board. This bill now actually cross-references 492, so it's very clear to not only the boards, the healing arts boards, which includes veterinary medicine, but also the individuals who are licensed, that even though you're going through the pretrial diversion program under Penal Code Section 1000, the board can use
The arrest, actually.
yeah, the record,
Yeah.
as well as the program itself,
Yep.
to discipline.
Yeah, I just, under section 1000.4, it's page 5 of 6 of the bill, a record pertaining to any arrest resulting in the successful completion of a pretrial diversion program. And it goes on to say that it basically shall not be used in successful criminals, it shall not be used in any way that could result in the denial of any employment benefit, license, or certificate, except that, as specified in 492, successful completion of a pretrial diversion program shall not prohibit any agency established under Division 2, which we are, of the code, or any initiative act referred to in that division from taking disciplinary action against a licensee or from denying a license for professional misconduct. Anyway, so there is a new catch-all.
Yeah, so the recent amendments actually help the board with its disciplinary action, so it arguably can't consider these PC 1000 arrests.
Okay, if I have a client who is applying for a license, does that person have to disclose this? Because I know the blowback I'm going to get is that because of this, that they don't have to disclose that. And we run into all this all the time with a client who has a conviction expunged, and then their criminal attorney tells them, you don't have to tell anybody, it's expunged. They don't call me, of course, until you deny the license. And then I tell them, expungement doesn't count, and the thing at that point is you're telling them that they won't get a license because they've acted fraudulently in lying to you, and also because they had 2 DUIs. So that's really my question here is that, and Tara, you explained that, great, what's happened here, but do these people applying for a license then have to disclose that? Because I know that the criminal attorneys are going to tell them that they don't.
The wording in PC 1000.4 says you don't have to.
Right.
But now that it's really clear that the licensing board can use the record.
Yes.
But the use of the record is different from the disclosure. So, I mean, I'm just suggesting that perhaps the board might have to be lenient or understand that if there is a person who applies for a license and answers no to that question, and then you subsequently, because of your background check, find out that they were involved in this PC 1000, that, rather than immediately denying a license because of fraudulent activity, you're going to have to maybe be a little understanding of the fact that if they read the wording and their criminal attorney reads the wording in that PC 1000, they're going to be told they don't have to disclose it.
I read C under 1000.4 to say the defendant shall be advised that regardless of his or her successful completion of pretrial diversion program, the arrest upon which the pretrial diversion was based may be disclosed by the Department of Justice in response to any peace officer application request, and that notwithstanding subdivision A, this section does not relieve him or her of the obligation to disclose the arrest in response to any direct question contained in any questionnaire or application for a position as a peace officer. Oh, just peace officer. Damn, I thought I was on to something.
No, I mean, see, I've read that. So I don't know that there's any answer, but I just wanted to call that to your attention.
I think that's a valid point because, you know, we are seeing disciplinary filings where they're arguing both, that failure to disclose and the conviction or the diversion program.
Right.
So, yeah, I think it is really important when, you know, reviewing applications to note whether or not it's the PC 1000. The 1203.4 does require disclosure.
Right.
But the 1000 doesn't. So, you know, keeping in mind that the applicants are just trying to do what people are telling them to do. They're trying to
You can still
comply.
deny the license, but it's just, you know, then we can just argue the underlying facts of the criminal case. But you're often denying the license on two grounds: because they were fraudulent when they filled out the application and because of the underlying criminal activity. So I would just urge you to be understanding of that fact. I mean, we still have to deal with the denial of the license because of the underlying activity.
So in the past, when there was a change to the penal code section in the 1203.4, the legal office did issue some directive to their boards and bureaus regarding how we need to treat these specific, whether they be whether they're withdrawn, dismissed, expunged, or a pretrial diversion. So I would anticipate something coming out from the legal office explaining how the clients are supposed to handle this. Do you have any comments, Mr. Heffler?
I will take that back to the legal office and report back to you in the future what the next step is.
Do we need to seek legislation to amend that? Peace officers have a special exclusion. Should the healing arts board have a special exclusion?
I mean, if you're asking my opinion, I think they should have to disclose it. How are we supposed to make a decision regarding whether or not this person poses a threat to the public if there's a certain amount of information that is, you know, kept confidential, and we're not privy to that information, yet we're responsible for making a public safety decision regarding a fitness to practice? So I don't know that I can advise you today because I don't know enough about the impact of this 1000.4 on how we're making decisions to license an individual. There are very few things that I'm aware of other than something that occurred under a juvenile court, prior to someone being an adult, that is protected from disclosure when you're seeking a license to practice in the state of California. This would be an exception to the general rule, which is if you are convicted, you have to disclose it. So I think we need to wait for further guidance from the legal office before we make a decision on how to proceed, if we need a legislative fix or we need to do something else. But I think if there is information that's kept confidential from a regulatory agency, that is not in line with our mandate for consumer protection. So that completes my report.
No motion at this point in time.
We don't need a motion.
Agenda item number 11.
Question about.
Oh, sorry. I do have a question. Oh, Can you come forward, please?
So I realize this is not on your agenda or something that you can comment on, but I asked Anne Marie and Tara yesterday if I could bring this up, and they said this was the appropriate time. So as you're all aware, last couple of weeks there have been these tremendous fires, and the CVMA is very heavily involved in those with our California Veterinary Medical Reserve Corps. Last Tuesday or Wednesday, we had a call. Dr. Miller is our point person for our CMRC, and we've had a lot of veterinary personnel deployed over in Santa Rosa. He got a call from one of the large emergency clinics, one of the very few hospitals that was able to stay open. Some burnt to the ground, and most of them, a good portion of them, didn't have electricity, weren't able to open, or veterinarian lost their home, or whatever the situation was. This particular hospital was taking in animals that were injured, and they were also receiving animals, actual owners coming in with their animals that were on regular medications. These owners no longer had a home. They no longer had access to those medications, so it was a really dire situation. So they were asking Dr. Miller, could they waive the VCPR under the circumstances, because they didn't have time to treat animals and then conduct a physical exam and go through the entire paperwork and so forth. So just the day before, I saw that the pharmacy board sent an email out to all pharmacists, and they have a regulation that says under a state of emergency, requirements for furnishing prescription drugs, providing emergency refills without authorization, and operating a mobile pharmacy are, I'm not going to say waived, but there's reasonable requirements that are waived under disaster situations, and they go on to list how a pharmacist is supposed to handle those types of requests during a declared emergency. So I reached out to Anne Marie, and she and Tara were just great and immediately got on it, saying there must be something that we can do. And unfortunately, there is really nothing that mimics what the pharmacy law does. However, Anne Marie and Tara were willing to provide us with a couple well-written sentences of how this could be considered an emergency situation, and a veterinarian could basically use their discretion and make sure you tell them to document that this was an emergency situation. So we relayed this to our member over at this practice, and they were quite grateful. However, it really pointed out something that I think the board really needs to take under consideration. Obviously, we cannot anticipate, the phenomenal disaster that this was, and this may not occur again for a long time, and it could occur next week. So I just wanted to bring the situation forward to you, because hopefully as you're looking at your legislation for next year, this is something you could look at, because I think we can all agree that it's badly needed. We just never knew it until this particular disaster. So thank you.
Thank you. So speaking of that, agenda number 11, discussion and possible board action on 2018 legislative proposals.
So we'll try to get through as much of this as we can.
Yes.
Before we have to end our day. Most of these you have seen before in some fashion. So if you go, I can't really follow the agenda because for some reason I lost my mind and I did them out of order in my document. So if you go to item 11, item 11, there is a document that outlines each of these requests for legislation. Don't get too hung up on the language, because as these things go through the legislative process, the Leg Council actually writes the language. But let's just talk about concepts and we can take them one by one. Veterinary assistant controlled substances permit, probationary license. What I'm requesting that the board do is provide me with affirmative action, provide me with the ability to seek legislation that would authorize us as staff to issue a probationary license to a veterinary assistant who holds who is applying for a controlled substance permit, similar to what we already do with RVTs. Just by way of background, for every 12 cases I'm looking at that have some sort of criminal history or disciplinary history, I would say greater than 85% of those files are veterinary assistant controlled substance permit applications. So they are taking up a great deal of time. Because there's no authority in law for our enforcement staff to offer a probationary license like we do with an RVT, my only option is to deny. And these individuals then would have to go through the hearing process, would have to appear before an ALJ, the decision would be rendered as a proposed decision, and we all know how long and expensive that process is. This would save both the applicant some time, money, and grief, and would also be less expensive to the board if we are able to offer the probationary license where appropriate, similar to what we do with the RVT. The board still has to approve those stipulated settlements for the probationary license. It would just prevent me from having to do an outright denial.
Dr. Sullivan?
Is this, would this, we envision this going like through an omnibus bill?
Yeah.
And I think at previous meetings, Candace had give us examples of how much time and how much money provisionary licenses were for RBTs.
Right.
And it's not just you trying to amass more power.
No.
As executive officer.
Thank you. I don't know if that statement might have been lost on the audience. No, it's not.
They're all tired.
Yeah.
Weird. Any other comments from the board? We do need a motion on each of these.
Yes.
And she's just looking for direction, looking for the concepts.
I think it's
So, motion.
very reasonable. Motion to accept.
Kathy, you seconded?
I think, yeah, you said motion to approve this in concept
Yeah.
or something?
Any other comments from the board? Any comments from the public?
I like chronic immunity. The term, chronic immunity.
I presume that the issue is that you're finding something when you, after they go through the fingerprinting, something turns up, and therefore you can't issue them a clear VACSP. How many of the ones that you've gone through the process end up being rejected after the process?
So we don't have actual stats, but I can tell you there are quite a few that I have to deny. So I don't have a statistic for every 100 I'm denying 12. Are they in your stats, Ethan, for tomorrow? No. We can get those statistics. I can tell you that the number of applications I see for any applicant who has a criminal history or a disciplinary history, I typically would see perhaps, trying to give you a ballpark figure, let's just say I review 30 files a month that for the various license types. 85%, and I've done my own statistics on how many of those that I'm denying are veterinary assistant controlled substance permit people versus RVTs and veterinarians. So it's substantially more that I'm getting criminal histories on for the VACSP category versus the RVT or the veterinarian.
And then of those, how many end up being ultimately, you ultimately reject them if they have a conviction for controlled substances? But if they have a conviction for driving without a license or something like that, then?
It depends on the factors. Did they complete their criminal probation? How long ago was the DUI? Is there multiple DUIs? So I can't answer that point blank because every case is individual. There are facts in every case that I have to weigh. Are there fines outstanding? You know, again, if they didn't complete all of their criminal probation, I would probably deny the license at that point because they never satisfied their criminal probation. So it just depends on the factors of each individual case. If they have a felony conviction for a drug possession, or they don't qualify to have a VACSP, that's not a denial, that's a disqualification.
So the denials are just for
Misdemeanors, it could be DUIs, it could be assault, it could be, I mean, there's a myriad of things that it could be that aren't felony drug convictions. Felony drug convictions do not result in a denial. They are not qualified to be a veterinary assistant controlled substance permit holder if they have a felony drug conviction.
So on what basis are you rejecting them if they have these other things?
I think I explained that. It depends on the length of time that they're, if it's sobriety, was it 10 or 20 years ago? Were there multiple convictions? Did they complete their criminal probation? So I go through a series of...
I guess my real question is, so what are the grounds for rejecting a person for a VACSP?
It's under 480. I mean, I think it's in here.
So is it the same as for...
Yes.
It's like a crime
yes.
related to the practice of veterinary medicine?
Yeah, or conviction of a misdemeanor or felony. Yeah.
Any other comments from the public? So we have a motion, a second. Any other comments from the board, I guess, first?
Oh, sure.
Motion to pursue
Yeah.
Yeah.
The motion is to pursue a legislative change that would allow for the board to offer a probationary license to an applicant for a veterinary assistant controlled substance permit that may otherwise be denied outright. And that ability to issue a probationary license would be similar to the decision to do so for an RVT based on criminal history and... I'm sorry?
Have you seen that long before? I must have.
Yeah. Well, I think I explained it not as a motion, but as a concept.
Well, and there was a second.
I see.
Yeah, Kathy second.
Call for the vote?
Okay. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
Dr. Nunez?
Yes.
Thank you.
Motion passes.
And, once again, do I have to read this, or we can do it after the whole thing?
Oh, no, that's just regs. So this is for statute, so we
Oh,
don't
good.
have to read that. Oh, Kathy, you missed out.
Darn it!
No, we don't have
It's
to
all
read
ready.
that. Okay,
What's next?
moving on, let's just go in order of the document. So page 3, veterinary student exemption.
This is still an NBC.
11A.
Well, it was an MDC, but this was also a proposal from the last legislative cycle. So since we need to be able to go to the Business Professions and Economic Development Committee or another omnibus committee to ask for legislation to be carried, it's timely for us to consider this.
Even though it's not ready.
So
Well,
moved.
it may be ready. So we have language that the MDC actually proposed, and this doesn't prevent anybody from weighing in on this language because it's going to go through the entire legislative process, and if there are comments, they will be heard. But there is language that the MDC worked through yesterday. I think Tara has a couple of changes to that language, but for the purposes of moving this along, Tara, do you want to review the language?
As long as everyone has it in front of them, it's item 6 of the hand carry MDC report, technically page 3.
Here, here.
So the revisions that came out of the committee yesterday are in front of you. What I would like to point out is that there are a couple things that could be viewed as substantive, so I just want to present this to you for your consideration quickly. In 5A1, the clinical training site, that phrase just came out of yesterday's deliberation. What was previously in the bill was off-campus or distributive site. I think that perhaps for your consideration, maybe you want to use off-campus or distributive site instead of clinical training site. It's a bit more descriptive. Also, in 2, the student should be has prior training. And these activities, it's like you're referring back to several items that are up under 5, so it's a bit confusing for the student. I think these activities could be changed to diagnosis, treatment, and surgery, for clarity's sake. Also, on 3, the supervision must be, I think that should be clarified as the supervision of the student is provided by a California licensed veterinarian. Also, the beginning of this starts with students of an American Veterinary Medical Association Council on Education accredited veterinary medical program may participate. This is a description of who is exempt from licensure requirements. So I think needs to change to who. May participate is really who participates.
So you're saying students who participate?
Yeah. Because it's about exempting the students in this situation.
Who participate? Okay.
Tara, can I see your document? Because I think for the purposes of the public, we should probably review it in totality. So the proposal would be, and again, we don't need to wordsmith it too much because the legislature is going to do their part. Students of an American Veterinary Medical Association Council on Education accredited veterinary medical program who participate as part of their formal curriculum in diagnosis and treatment with direct supervision or in surgery with immediate supervision, provided the following requirements are met. A, the off-campus or distributed site has been approved by the university where the student is enrolled. B, the student has prior training in diagnosis, treatment, and surgery as part of the formal curriculum. And C, the supervisor of the student must be a California, or supervision of the student is provided by, a California licensed veterinarian in good standing as defined in, and so on. Does that capture everything there?
Yes.
Okay.
I don't know if that makes sense, though, because you say you may participate, it originally said you may participate provided the following are requirements are met. And then you say, who participate?
It should be
provided the following requirements are met.
It should be who participate. So we're providing a description of a student who's exempt from licensure for diagnosis, treatment, and surgery. If the following three items have been met.
So, I mean, it said, these students who participate provided the following requirements are met.
Yes.
That doesn't make
It
sense.
seems to imply they can't do it on campus, to me. I mean, it's very specific to this.
I mean, it's like who participate can do so provided the following requirements are met.
I think we're getting stuck on wordsmithing and it's not going to be up to us in the long run. So,
The line is now.
So Dr. Sullivan originally had made a motion, very quick motion after this was read.
Well, my motion was to move this concept forward.
Yeah.
To
Yes.
give it a legal, or to give it to legislation.
I can second that.
Okay, we have a second? Any comments from the public? Yes, Dr. Clinton.
So my interpretation of 5A, first of all, is that the original 5A and 5B, 5A was students within the university setting who were getting their education, and 5B was those in off-campus and distributive sites. And when we struck 5B, we changed the language in 5A to be inclusive of both on-campus and off-campus sites.
Right.
So I felt that the language yesterday, I wasn't going to wordsmith with the group, but I felt that the language in 1, or I, as you want to call it, clinical training site, actually should have said veterinary medical program to maintain consistency. The veterinary medical program has been approved by the university where the student is enrolled. That is both on campus, off campus, and distributive. That's an inclusive statement. It is part of the formal curriculum. The other thing that I had thought, since we're here talking about it, is that the beginning of this entire section should be, as part of their formal curriculum, comma, students of an AVMA COE school may participate in diagnosis and treatment with direct supervision or in surgery with immediate supervision. And I just felt that that flowed better than all of the phrases that we have in there. But the intent of 5A, as it's been rewritten, is to include all forms of education, and the exemption in 4830 is for education in all sites, not just off-campus or distributive. We're allowing them to practice veterinary medicine without a license.
I like the arrangement of the introduction. I do think, though, saying that the veterinary medical programs has been approved, that means something else. So we're actually talking about the site where the student is being placed, whether it's a distributive model or whether it's somewhere on campus. If you're saying the programs approved by the university, you're talking about the entire veterinary medical program, which means something else. And we're talking about the site where the student is actually going to be providing services to the public's animals.
Okay.
So I don't think program would be the right description. I do agree that when we were talking about this clinical training, it could be on campus or off campus. And I think somehow we need to capture that. Because the VMTH is on campus, but these students are providing services to the public's animals. And what we want to make sure of is if they're doing that, and this is part of their formal curriculum, that these requirements have been met. So whatever words we can come up with that says and I don't know, externship has a meaning that externship may not be the right terminology, but we can definitely work with the universities to find that terminology to encompass both off-site and on-site experience.
Thank you.
Thank you.
Any other comments from the public? Jamie says,
Yeah.
I did. Okay, so we have a motion and a second.
Which language are we? The concept of this one.
The concept of the language that we just discussed with, yeah. At the end.
Got it.
So we don't.
Is
Call
there
for the
any-
vote.
No more public comment?
I asked.
Oh, you asked, okay. All right. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez? Thank you. Okay, so Tara, we got our work to do. So, moving on, page 4. Okay, page 4, the veterinary student or the veterinary graduate RVT duties. This is the exact language that the board approved at the April 2017 meeting. This essentially gives the board a prospective, basically gives due notice to those that are graduates of a recognized veterinary college that are performing duties as an RVT but never got a license as an RVT, that the window of opportunity is going to close. That's the best way to say this. Tara, I would ask that we probably need to move this date out to 2020 to give them advance notice.
I agree.
Okay. So this would say that by 2020, if a graduate of a recognized veterinary college is performing animal health tasks otherwise performed by an RVT, the graduate has to discontinue providing such duties unless they get licensed. That's the gist of it. And the board has previously approved this concept, so I'm just asking you to say, go for it, make it happen.
So if we've already approved it, why are we approving it again?
Well, because I'm changing the date to 2020.
Well, we have to talk about it.
Okay, let's talk about it. I'm changing the due notice.
Any comments?
I know.
I mean, answer is that this is actually, we approved it, but
Yeah.
now we have to put it into a.
A bill,
yes.
Yeah, that's what we're,
With your vehicle, that's what it
that's
is.
what we're doing.
Yeah.
Okay. Then let's put the concept we already approved on into a vehicle.
With a 2020 effective date.
I guess I'm just second that, appears to be a motion.
Was that a motion?
It's close to a
It
motion.
was.
Okay, so we have a motion and a second.
Close enough.
Is there any comments from the public?
I would just like to suggest that you also recommend to the MDC that they look into creating a new eligibility category for the RBT exam. That a person who is a graduate of a recognized veterinary college be able to sit for the California RBT exam.
They can't do that now.
We can't do
We
that?
did talk about that.
There's no specific category. They could use the alternate route, but that would require 2.5 years working under some California veterinarian.
Yes, I believe that when we created 2027.5 under the MDC, which would not be able to go into effect until this did, we provided for an avenue for these graduates to take the RBT exam. So that was already discussed and approved by the MDC. We just can't move forward with implementing that into regulation until we do this by statute. And that was the new 2027.5.
Okay.
Is that everybody else's recollection?
I recollect something, I don't remember.
I don't remember that we approved them taking the RT exam.
Ethan,
Remember
remember the work
talking
we
about
did?
it.
I think it's in
Well, if it hasn't already been done, it should be
Yeah,
done.
I'll look into it, but I believe 2027.5, the new 2027.5 accomplishes that.
Any other comments from the public? Any comments from the lion watcher?
What happened? What's
Yeah.
going to do?
Any more comments from the board?
I think we've all seen something shiny, so I'm going to call for the vote.
Yeah, that's a good idea.
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez?
Yes.
Okay, I think everyone's going to be thrilled when I say we can disregard the next one.
Sure we will. BLE.
You want to know why we're going to disregard it?
I do.
Does someone want to know?
Yeah.
Tell us.
Okay, so the OPES came before the board at its April meeting and said the VLE for the veterinary law exam for veterinarians was adequately covered under the California State Board exam, and therefore applicants who already take the VLE should not need to take, or excuse me, that already take the California State Board exam shouldn't have to take the VLE. They don't typically take both exams anyway. The problem is what they wanted us to do, the board said we don't want to do away with the VLE because there are several licensing categories that don't take the CSB. Reciprocity doesn't take the California State Board exam. University license wouldn't take the state board exam. So the board was not in favor of removing the VLE. Because of that, the OPES said, well, technically, this is not an exam. It's an open book resource tool. So we should change the name of it. Changing the name of it doesn't provide any benefit to any of us. In that, we still have to, if we're going to administer it as a prerequisite to licensure, we still have to validate it. We still have to go through and do workshops. We still have to have exam security. So I would suggest that we disregard changing legislation that is not going to have any administrative or financial benefit to the board. But we can do it if you so choose.
So, does that mean everything stays as it is right now?
Yes.
And I think Dr. Nolan brought up that we'd also be losing money from an already very tight budget.
Any other comment on that? Any comments from the public on that point? Okay, can we move on to the last one in this section?
I think that was the last one.
No, 26.
Oh.
The hospital.
Okay, so the very last proposal is again something that was in SB 546, And I'm just asking for you to say, move forward and put it back in a vehicle. It was removed for fiscal reasons. The Appropriations Committee was concerned about how expensive it would be for the board to meet our 20%. Yeah. So they're concerned about that. So what we'd like to be able to engage in a dialogue that says, if you make us do that, if you build it, they will come. So if you make us do this and it's a mandate, the Department of Finance can fund it through the licensing fees. So I'm just asking for the board to approve this as another legislative initiative.
Dr. Sullivan?
Yeah, I think that's a legitimate concern because we do go through economic cycles, and when we have the next downturn and the governor decides to take some of our money or whatever mechanism they use, now we've got a mandate to do 20%, and we may not have the money to do it. So how does an agency handle that situation, or a board?
The same way we do when we have a mandate to enforce the laws and to take disciplinary action and we run out of money and we have to stop doing it and we have to explain that we had to stop doing it because we ran out of money. So it happens in all program areas. And there's been times in the past where we've actually had to discontinue enforcement because there was no money left. So this is no different than any other program within the board.
And then the staff would, or the board would then prioritize where the cuts are, where the program, okay.
Kathy?
And I think from a public perspective, it's certainly with consumer protection in mind, that a 20% inspection is minimum of what we should be able to do, and that we should be funded for it. So, I mean, for public protection, I think we have to. So I think it's good to clarify it.
I think this is hospital inspection is like the most effective tool that we have to try and advance veterinary medicine.
Well, remember, we're not trying to advance it though, as the board.
Whatever term you want to use there.
It's our most effective tool for outreach.
For outreach. Any other comments? So do we have a motion?
Motion to approve that.
Second.
Moving forward.
We have a motion second. Is there any comment from the public? Any other comment from the board? Call for the vote.
Okay, Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bowler.
Yes.
Dr. Nunez.
Yes.
Dr. Nolan.
Yes.
Motion passes. To agenda item number 12, public comment for items not on the agenda.
Anne Marie, you were right about 2027.5. We did, in January of this year, we did pass that to allow students within 8 months of graduation to sit through their RBT exam.
Okay.
Right. So I was wrong about the law enforcement officer, but I reviewed myself. It's been a good day.
It's a blush.
So hearing no items for future agendas, we will recess until tomorrow morning at 9 a.m.